A little bit of a follow-on, and I don't want to get set for too long on the legal issue, but I do want to ask the understanding of a question of law. When does the law change? So when are you legally able to follow a particular line that might be before the courts? And my understanding of that, and certainly the Deputy Minister says, you've got to follow the law. So my understanding is the law only changes once the court changes it. So at the moment, the law is basically requires you as a social insurance fund to report as a social insurance fund. You actually aren't allowed to report as anything else because the law hasn't changed. It might be a matter before court. You certainly had a full bench which have turned you down, and you're now relying on the Chief Justice. But the reality is, and he may well change the situation, the law doesn't change until he actually says so, basically, or until he says not, basically. So the question I'm asking here, because the Deputy Minister quite rightly said in the SARS case, you've got to follow the law. Why are you not following the law in this case? In the case with the Auditor General, why are you not following the correct procedures as laid down in law? And then the second question I want to ask is I want to ask a question of the board. How do you feel in terms of the King principles of actually facilitating what is effectively, I don't want to use the word an illegal course of action, but you're not following the law, basically. And are you not concerned that you could be seen as delinquent directors by enabling a situation where you continually get your disclaimers because you're not following the law? So I want to get an understanding from you as to when you think the law changes. And if you think I'm right by saying it only changes once the court changes it, and you are obligated to follow the law until the court changes it. Okay, I'd just like an answer on that one, and then we can carry on.
So can I, for ease of, so every time a member asks a question, please just proceed with an answer. I don't need to interject between you. I'll only make interventions of time and clarity.
No, thanks, Chair. As it were, in law, there is a thing called eau de grace principle. Eau de grace principle says an administrator's decision or an administrative decision remains in force until reviewed and set aside. A decision of the board or R.A.F to go through a thing called an accounting policy change in an administrative decision. No one has said that thing and set it aside. No one. So at this point, there is another principle in law called funtus. Once an administrator has taken a decision, they are not allowed to revisit that whole decision unless it's changed by the court. So if I take a decision to appoint someone and I realize I've made a mistake, I go to court and set aside that decision of mine. I don't go and change it on my own, unless then I'll be puntus officio. So there are those principles. But let's then deal with this other issue of legality. So when you go to court and the court below decision is either appealed, there is provision 18.1 of the Supreme Court Act that says that that decision is suspended, of the court is suspended until the appeal is heard and finalized. So all those things are applications of law that we have followed. And I must emphasize that Section 34 of the Constitution is quite clear about who can approach the court. Any person can approach the court to resolve adjudicate over a dispute through application of law, and that's exactly what the R.A.F has done. So, so far as we are concerned, all those principles given, we believe very strongly that we are on the right side of the law. Thanks.
Okay, it was my understanding that the full bench of the High Court or the Supreme Court basically told you to stick with what the social insurance fund. And I know that you've gone forward to the Chief Justice to ask for that to be overturned. But to my mind, that's the law.
Once you appeal in terms of Rule 18.1 of the Supreme Court for Supreme Court rules, a decision taken by the court is suspended. So suspended means it's not in effect. So that which the court has said, once we appeal or put in our leave to appeal, is suspended. We have done that, Chair, I must emphasize. We came to this committee earlier on the Logodi issue, where we were told we are going to pay our, we are hit with the personal cost orders, as both me and the board. And I even said that, I said, well, we have appealed that judgment. We have won that judgment. The SCA has overturned that. But between those things, we didn't pay because it was suspended by the appeal. So once you appeal, 18.1 of the court rule says it's suspended. That's the law.
Okay. Then I'm going to follow on with regards to the documents that you require to have a valid claim. Okay, you have your board minute, and I see that Acting Judge Kolong in the Eastern Cape basically said that you cannot turn down a claim by asking for people's proof of income and various other things. So in other words, they're saying that you've got to stick to the provisions of the Act, and that you can't, that your board minute, which places additional requirements on people, is actually not valid. So my concern there is that you're rejecting a lot. You're actually rejecting a lot of claims that are potentially valid in terms of the law, and potentially valid in terms of the R.A.F. Act, in terms of the requirements of the section. So, yeah, it's Judge Kolong in the Eastern Cape Court in the last few days, I think, has basically said that you cannot demand proof of income from people, and you can't reject a claim on that basis. Okay, so my concern is that we're seeing the financial break. We're seeing your financial statements, but it's based on your board minute, which obviously is an issue because you're asking for documentation that the courts have basically said that that are not required. So, how accurate are your outstanding liabilities if you're asking for documentation that's not required, or things that are actually valid claims that you're saying are invalid claims?
Yeah, I think we're gonna have to rely on the Auditor General at all material times, whether we agree with them or we disagree with them.
Yeah.
You are of the opinion that they are right when they are saying that we are using a wrong standard. But it would seem you have difficulties, Honorable Member, in finding, in relying on what they say when they say our liabilities are the way they are. Because we don't disagree on that. So at least let's rely on them consistently. If we rely on them consistently, we differ with them on that, we don't differ with them on that. So they do look at our liabilities and they express an opinion on them. Okay, we disagree on one aspect of the liability, which is the backlog and how we evaluate that from an actuarial basis and all that, and that's the only thing. So the Eastern Cape High Court has got views. Once we realize that, you will find that we appeal those. Because how do we arrive at a point when we are able to determine your loss of earnings if we don't know how much you earn? That's absurdity of the West Order. There can't be someone who can tell us that Collins earns this much, but he must not prove that he earns that much for you to calculate how much he earns. That's quite absurd. And we will of course appeal that if that is the outcome that we have received. You said it's a few days ago. It will probably be making its way to the head office, and of course we'll appeal it. Because we don't think that, I mean, we had another one that we are also appealing at the Constitutional Court. at the SCA that suggested that we must agree to people not giving us copies of IDs or ID numbers at least, for us to know the hospital serviced call-ins. Now they say, no, you don't have to give. I mean, the guy can come and claim at R.A.F and we must just give them, without them identifying who they were servicing. It's absurd, right? So all we are saying is, courts do err at times, and when they make mistakes, that's why there's a higher court that we'll go to. Because when we disagree, we'll disagree. But you can imagine the floodgates that says anyone can come and claim that they were earning this much and they don't have to prove it, because we don't want. But also there is a provision of, I think it's section 4 of the Act, powers and functions of the fund. The powers and functions of the fund shall include A, the stipulation of terms and conditions upon which claims for compensation contemplated in 3 shall be administered. I'm sure that must mean that we must put terms and conditions. And those terms and conditions include the documents we would require from someone for us to be able to settle the claim. The aim of R.A.F is never to sit there and say to people, you are not so entitled to this money. It's not our, but we are given a kitty that belongs to South Africans that we must manage. And we must manage this thing diligently, as if it was our own. You can't just come and give someone money like that and say, no, we are told we must not ask for proof. So where there is judgments that are saying, don't ask for proof, we are going to have to strenuously argue differently. And of course, the only way you can do is appeal those matters.
Okay, and then if the courts don't agree with you?
Well, we'll take it to the Constitutional Court. If the Constitutional Court does not agree with us, we'll let it be. But we'll come to this committee and say, they are saying we must pay people that do not have proof that they are earning, loss of earnings. It's fine. I mean, if they then decide, they've decided. But all we can do is that if it goes to the SCA and we lose, we'll take it to the highest court because we want that decision. And once that decision is taken, of course it becomes law. Then we'll adhere to it, as it were. Thanks.
Okay. With regards to your investment income, I see there's been quite a significant increase in the amount